appeal for judgment, the Queen on the application of Sharon Kenton-Cross and others, and the Secretary of State for Work and Pensions.
For the reasons given in the judgment, which I now hand down, this appeal is allowed and the claim is dismissed. Consequential orders are in accordance with an order which the court has approved.
Appeal on the matter of the Queen on the application of Open Rights Group and another, and the Secretary of State for the Home Department and another.
My Lords, I appear with Mr. Grubeck for the appellants, Sir James Eady and Mr. Jones for the respondents, and Mr. Knight for the information.
Yes, Mr. Jones. I'm sorry we had a slightly late start.
That's quite all right. I propose to deal with three questions on relief. First of all, whether the court has power to suspend the disapplication of the immigration exemption. Secondly, if it does, what the principles are governing the exercise of that discretion. And then thirdly, whether and how the power should be exercised in this case.
Thank
you. In brief, yes, we say the court does have power to give relief suspended for a period to allow the Secretary of State to lay regulations remedying the illegality and then for Parliament to decide whether or not to approve them. The principles which govern the exercise of that discretion are strict necessity, justified by evidence showing the involvement of an important public interest. And of course, any limitation on relief ought to be as short as possible. It's an exceptional remedial discretion and ought to be, we say, approached as such.
Mr. Jaffe, I'm sorry to interrupt you, but is this a jurisdiction which rests exclusively on EU law, or now retained EU law? Or on your submission, does it have any wider compass?
I was hoping to avoid answering that.
All right, we'll avoid answering it. We don't need to answer it in this case.
Yeah, exactly. For exactly that reason. There is a very interesting question about the extent to which, if the court finds, I mean, first of all, it wouldn't arise in the context of an ordinary judicial review because, of course, the court has no power to consider the lawfulness of primary legislation.
Yes,
and so yes, that issue
is more in the context of secondary legislation.
Now, in the context of secondary legislation, there is already quite a lot of learning in the kind of pure judicial review, non-EU law sphere, going back to, for example, Boddington and cases before that, about what effects an ultra vires act may have. And that's, of course, still an area of some controversy.
And did the Supreme Court touch on this in Ahmed and HM Treasury?
They did, yes.
Right. So this is probably territory we should be careful to avoid.
Yes. And that's because there are those difficulties, because an ultra vires act may have legal consequences, but as the Supreme Court said in Ahmed and HM Treasury, that was this type of suspended disapplication was not a route that they were prepared to consider in that case, in that context. And so I think the parties, I think are agreed about the legal principles broadly, are agreed that these are principles of retained EU law that the court is being asked to apply.
So your position is, for present purposes,
yes,
we are concerned only with a retained EU jurisdiction.
Yes.
Whether there might be some equivalent jurisdiction as a matter of common law, you haven't come prepared to argue, and we don't need to decide. Is that it?
I think the court certainly doesn't need to decide it in this case.
Okay, that's very clear. Thank you.
We do accept also that the discretion ought to be exercised in this case for a short period, but with those caveats firmly in mind. And so we say the court should give a date by which its relief will take effect, not merely a date on which the Secretary of State should lay some draft regulations before Parliament. And given the unusual nature of what is proposed, the timetable also ought to be exacting and require action to be taken at a reasonable pace. And what we propose is we originally suggested when our submissions were drafted that the end of November ought to be an end date. Given the date of the listing of this hearing, I suspect it will be said that's unrealistic. The Information Commissioner's proposal is the end of this year, the 31st of December, and we are reluctantly content to agree with that proposal. What we also say, and we understand the parties disagree about this, is that any suspended order ought to be limited to the public sector only. And that's because the only evidence which has been adduced of any problems that would be caused by the court granting relief are problems within the public sector only. And so we say it's unnecessary for the court to take any step in relation to private sector usage of the immigration exemption. And it may be that the private sector usage is more concerning in practice than the public sector usage, because the court's judgment is that there is an inadequate regime of safeguards and controls governing the use of the immigration exemption. And so, therefore, action taken by the private sector, which will generally be done in secret, I don't mean secret in a pejorative way, it's just the reality if that's how it will be used, potentially involves greater interferences with rights than those committed by the public sector. So that's where I'm proposing to go, if I may. On the law, I'll mention first, if I may, the domestic cases, then the Court of Justice's recent authorities, and then finally the effect of Brexit. As for domestic law, I can take this relatively quickly. It's now reasonably well established in the domestic law cases that the court has the power to tailor, in cases involving EU law, its relief in appropriate cases. The leading case on that, albeit the court's analysis is only obiter, is Lord Mance in the Supreme Court in Chester, the prisoners' voting case. I don't know whether the court wants me to go through it, but I suspect you'll have seen the references to it, and it's also quoted in detail in the Divisional Court's judgment in Liberty, that we're probably coming to in a moment.
Yes, I think, speaking for myself, I think probably let's just look at it in the Liberty context. Yep.
So the upshot of that case is that there was an EU law issue as well as the European Convention on Human Rights issue. And the EU law claim was rejected on its facts, but Lord Mance also said that even if the EU law claim had succeeded, the court would not have granted immediate disapplication of the relevant rules preventing prisoners voting, because there would need to be a scheme which was introduced by Parliament. And given that the claimants in that case were all lifers, and Parliament on any view may have been able to have a scheme which excluded lifers from the right to vote, then it wasn't appropriate for the whole scheme to fall. The appropriate order would have been for declaratory relief and then leaving it to Parliament to introduce a new scheme, at least initially. So that's the upshot of that, and it was of course obiter analysis, but persuasive nonetheless. That analysis was then applied by the Divisional Court in Liberty, which I will go to if I may. Liberty is tab 6 in the authorities Bible. As my Lord Justice Singh will recall, this was a challenge to various parts of the Investigatory Powers Act 2016, and the court in this part of the litigation was dealing with the power to require retention of communications data by telephone companies and internet companies. And the issue which arose in that case was that the Court of Justice, in cases the court looked at in this appeal, Telly 2 and Watson, decided that one of the safeguards that was required for retention of communications data is there needed to be a system of prior independent authorization before access could be granted to that retained data. So before you could retain, you needed to have a scheme in place under which there'd be independent authorization for access to it. Now, the UK scheme didn't have that safeguard, and so therefore there was an incompatibility with EU law. So there are some obvious similarities to this case, because the retention of communications data took effect as a derogation from rights granted by EU law. And in that case it was the e-privacy directive, and in this case it's the GDPR. Now, the consequences would have been pretty serious if immediate disapplication had been ordered, and that's because, of course, communications data is a very important part of evidence in pretty much all criminal cases of any seriousness, and a very important part of police and other investigations. What the court held, and And if I can pick it up at paragraph 75, on page 500 of the report, is first of all at 75 that EU law did permit the retention of communications data in principle, and the failure was one of safeguards. And introducing those safeguards would require positive steps by way of amending legislation, and in those circumstances it wasn't appropriate to disapply immediately. The court then noted at 76 that these were deep waters, and the government ought to have a reasonable opportunity to correct the position, and also noted that these are unfamiliar areas for English courts because of a lack of history of constitutional adjudication. Then Chester was cited and applied from paragraph 78 onwards, and then the court's decision starts at paragraph 92. The court said, first of all, that it wasn't prepared to contemplate the grant of a remedy which would have the effect of causing chaos and the damage to the public interest, understandably. And then paragraph 93, a coercive remedy wasn't necessary or appropriate because of the delicate constitutional context. But equally, 94, it wouldn't be just or appropriate for the court to give the executive carte blanche to take as long as it likes to secure compliance. It has to be a remedy within a reasonable time. And in that case, one of the problems was that in order to remedy the incompatibility, what would have to happen is a whole new public body needed to be set up, the Office of Communications Data Authorisation, which had to be staffed, and the staff had to be trained to be able to take independent decisions on those authorisation applications. So what the court ordered, and this is paragraph 99, is that the appropriate legal framework needed to be put in place by April 2019, with the practical implementation to follow once the staff had been recruited and trained. So the date for legal compliance was just over 6 months from the date of the judgment, and that's the end of 99. And then the court's order is summarised at 100, that there would be a declaration specifying the incompatibilities, stating they must be remedied within a reasonable time, and identifying what a reasonable time is. Liberty to apply was also granted to allow for any necessary changes to the timetable. So that's the domestic jurisprudence. Since then, we've had the benefit of the analysis of the Grand Chamber on similar issues, and there have been 3 Grand Chamber decisions touching on these topics since Liberty, the most important of which is La Quadrature du Net. La Quadrature is tab 7 of the authorities. These are La Quadrature du Net and the other cases that were joined with it all raise very similar issues to the Liberty case, and Telly 2 and Watson as well. These cases, and in particular the Belgian case, where the issue of relief was discussed, were about Belgian law on data retention. And there were a bunch of questions referred about whether various aspects of Belgian law relating to communications data were compatible with EU law. But the Belgian Constitutional Court also asked the question of whether it could limit the temporal effect of any declaration of illegality, which it ultimately made following the reference. So they wanted to know the same answer to the question which was posed in Liberty and Chester. So the question that was referred is at paragraph 213 of the judgment, on page 1238. So the Belgian Constitutional Court wanted to know whether it, as a national court, may apply a provision of national law empowering it to limit the temporal effects of a declaration of illegality, which it's bound to make as a result of EU law. And then the court's answer starts at 214. The court starts, unsurprisingly, by referring to the principle of the primacy of EU law, and then at 215 says that the national court has a duty to give effect to the primacy of EU law, and then 216, only the court, and it's the court with a capital C, the Court of Justice, may allow the temporary suspension of the ousting effect of EU law or national law. They cite then various cases for that proposition. We will look at, if I may, the last one of those cases for a couple of propositions in a moment. But then there's an explanation at paragraph 217 of what's going on. The court says the primacy and uniform application of EU law would be undermined if national courts had the power to give provisions of national law primacy in relation to EU law contravened by these provisions, even temporarily. Now, the court then recognised in the following paragraphs that that was slightly strange, because in previous cases the court had recognised that national courts could do precisely that. And so in paragraph 218, the court accepts that it has allowed national courts in the past to impose temporal limits on disapplication. And so it cites one case in which that was considered, the Inter-Environment Wallonie case. And then the explanation the court gives at 219 is that that line of case law applies only in cases involving a procedural obligation, in that case to carry out an environmental assessment, not a substantive failure to comply with a provision authorising a derogation from fundamental rights in EU law. Now, this distinction that you see in that case between procedural rules and substantive rules is, as far as we can tell at least, new to La Quadrature du Net. It hasn't appeared in EU jurisprudence previously. I hope I'm not being overly critical if I say it's not entirely fully reasoned. But it's also not completely unexpected that the Court of Justice might say something like that. And that's because there are many contexts in which the Court of Justice has said things along the lines that only it should take certain steps that will have potential effects across the Union. And so one area in which the Court of Justice has always reserved jurisdiction to itself is, for example, disapplying an EU instrument, which it has always said that only it can do because of the potential consequences in other states. And the same reasoning is offered, it's legal certainty. So the court, having identified this principle of distinguishing between procedural and substantive cases, the court then offers the Belgian court a solution on the facts of that case. And what the court does is it says, well, it's not necessary to suspend the temporal effect of any decision because criminal courts in Belgium do not necessarily have to exclude communications data that's been obtained unlawfully from criminal trials. And then the court identifies a test which, as a matter of EU law, should be applied to the admissibility of that evidence in criminal proceedings in Belgium. So in paragraph 222, the Court of Justice says, to give a useful answer to the referring court, it should be recalled that as EU law currently stands, it's the national law to determine rules relating to admissibility and assessment in criminal proceedings of evidence. And then at 225, the court says that, applying the principle of effectiveness, the objective of national rules on admissibility and use of evidence is to prevent information and evidence obtained unlawfully from unduly prejudicing a person who's suspected of having committed criminal offences. That objective may be achieved under national law, not only by prohibiting the use of such evidence, but also by means of national rules and practices governing the assessment and weighting of such material, or by factoring in whether the material is unlawful when determining sentence. And the court then refers to its previous authorities at 226 on fair trials, and then the test which the court identifies is 227. The principle of effectiveness requires national criminal courts to disregard information and evidence obtained in breach of EU law in the context of criminal proceedings and so on, where those persons are not in a position to comment effectively on that information and that evidence, and, so two requirements, they pertain to a field of which the judges have no knowledge and are likely to have a preponderant influence on the finding of the fact. Now, of course, in most criminal cases, in fact in all criminal cases in this country certainly, all of the evidence will be available to the defendant. And so that test is easily satisfied. Even if all the evidence is not available to the defendant, communications data is not obviously a field in which judges have no knowledge and where judges cannot for themselves assess the reliability and probative value of the evidence. So that's the solution which the Court of Justice came up with in that case. Now, those principles have been applied more recently by the Grand Chamber of the Court of Justice in another case called B in Latvia. B in Latvia is at tab 8. The issue in this case, it's a data protection case, was whether there ought to be public access to a database which showed how many penalty points every Latvian driver had on his or her driving licence. And the Court of Justice held that there should not be an automatic right of public access, that someone who wished to know how many penalty points another driver had to have some form of cogent reason. The court also refused to suspend the effect of its decision temporarily, and that was the subject of one of the questions that was referred. So paragraph 130 and onwards is where the court considers this, on page 264, and the numbering on the bottom right. And I'm showing you this because at paragraph 132, the court identifies a test of principle which it applies to a request for a temporal restriction on its judgment. So from the fourth line, it's only exceptionally the court may be moved to restrict for any person concerned the opportunity of relying on a provision which is interpreted. And then two essential criteria must be fulfilled, namely that those concerned, first of all, should have acted in good faith, and then that there should be a risk of serious difficulties. And then at 133 to 135, we get the same reasoning as appears in La Quadrature as to why this is a decision for the Court of Justice. And the reasoning is again to preserve the unity and effectiveness of EU law. And then the argument is rejected on its facts at 136. Now, jumping ahead slightly, of course, that logic about the unity of EU law has no application to EU law which has been retained as part of English law after Brexit. The Court of Justice, of course, cannot any longer exercise the power to suspend the disapplication of an inconsistent national provision, and that's because Parliament has decided that no further references to the Court of Justice are to be possible, except in the limited category of cases arising under the Northern Irish Protocol. And of course, the whole point of Brexit and the EU Withdrawal Act is to remove the principle of the automatic uniform application of EU law in the United Kingdom. The conundrum, of course, is that EU law has also been retained in some cases, in some circumstances, by the choice of Parliament, and EU remedies continue to apply in certain cases, including this one. And so we suggest the obvious solution is that this court ought to exercise that discretion.
Is that your submission or trailing a submission you're going to make later?
That's trailing a submission I'll hopefully improve later.
And then it's good so far, but requires a little bit further digging.
Yeah, it does require a bit further unpacking.
Okay. No, that's fine. Well, then I won't ask you any questions.
No, but there are questions, and it does require a little bit of unpacking as to how you get there.
Okay.
The final Court of Justice authority, just to complete the picture, is a case called Gewesterleicher. That was one that was handed up, or it was sent by email yesterday, and there should be a copy on the bench, I hope. This is another Grand Chamber authority. This one was handed down before the IP completion date, 31st of December last year, and so therefore it's still binding authority subject to the regulations. And this is also one of the cases that was cited in La Quadrature.
Oh, sorry, which case are we talking about?
Gewesterleicher.
I'm sorry.
Yes. And it's Grand Chamber as well, and it's also prior to the IP completion date.
So sorry, it predates La Quadrature.
It predates La Quadrature, it was cited in La Quadrature,
Yeah.
and it also predates IP completion.
As indeed does La Quadrature.
As does La Quadrature. But the Latvian case does not. The Latvian case postdates IP completion date. So it is not binding authority, subject to the regulations. It is only of persuasive authority.
Yes, we're still entitled to look at it.
Take
it into account.
You may take it into account to the extent you wish to, but it is not. It does not have any binding status.
Yeah.
And I show you this because it's the source of the test of strict necessity for the exercise of this remedial discretion, and that statement is at paragraph 94 of the judgment.
Yes, that's all you're going to take us to, isn't it?
Yes.
Yeah. Fine.
That's just another case in which those principles were applied on particular facts. That was a case involving planning, and the test was considered and applied, and it was stated the test is one of strict necessity. So that's the current state of the Court of Justice case law. Then the final piece of the legal structure is Brexit. The court's already analysed the position in relation to Brexit in its judgment in paragraphs 12 and 13. And in very brief summary, the upshot is that the pre-IP completion date case law remains binding on the court in this case. The court will also apply, because Parliament has told it to, the principle of supremacy of EU law in this case. And I emphasise that's because of Parliament's choice as to how EU law should apply in cases like this. It's not because of some residual effect of EU law. And also, it's Parliament's choice that in the future, Article 23 of GDPR, which was the provision at issue in this appeal, should continue in place in the United Kingdom essentially unchanged in the UK GDPR. Now, there are two caveats to those issues of EU law. The first caveat is one I've already mentioned, which is that no further references may be made to the Court of Justice. And that's section 6.1 of the EU Withdrawal Act. So the principle of supremacy continues to apply. Some EU authorities continue to be binding, and the court applies EU law principles, but no further preliminary references. The second feature arises out of the first one, which is that because preliminary references cannot be made anymore, there needs to be a mechanism for dealing with the binding effect of Court of Justice case law and departures from Court of Justice case law. Because the Court of Justice doesn't bind itself, and case law will continue to develop over time, so some mechanism needs to be created in national law to enable such departures to occur. And the mechanism is the retained EU case law regulations 2020. Those regulations are in the bundle at tab 4, so the authorities bundle at tab 4. Regulation 3 prescribes a number of courts in the United Kingdom as relevant courts, and they of course include this court, the Appeal. Regulation 4 provides that a relevant court is not bound by any retained EU case law, except as provided in paragraph 2. And paragraph 2 deals with cases where there is post-transition domestic case law that's already binding. So if, for example, there is a decision on point post-transition by the Court of Appeal, then this court would ordinarily be bound by it, and equally a decision of the Supreme Court post-transition. So that just implements domestic principles of precedent, is in a sense pretty obvious. Then Regulation 5, the test for departing from retained EU case law, is the test the Supreme Court of the United Kingdom would apply in deciding whether to depart from its own case law. So what is that test? Well, the Supreme Court still applies the 1966 practice statement on judicial precedent. We've handed up a copy of that, which is also on the bench. And it will be familiar to the court. The second paragraph between F and G modifies the previous practice. Decisions of the House are normally binding, but may be departed from where it appears right to do so. But the court will bear in mind the dangers of disturbing retrospectively the basis on which contracts, settlements of property and fiscal arrangements have been entered into, and the especial need for certainty as to the criminal law. So that's the legal framework. Now doing that little bit of unpacking as to how it may apply in this case, we suggest there are two issues. The first issue is there binding Court of Justice case law on this issue, which constrains the court? And secondly, if there is, should this court depart from it in any way? So the first task is to identify the ratio of la quadrature. And the ratio seems to be that time-limited disapplication is a task for the Court of Justice only in cases involving derogations from substantive rights. So that, of course, raises the obvious question, is this case a procedural case or a substantive case in that taxonomy? Well, we have two examples of substantive cases so far from the Court of Justice. We have la quadrature itself, and we have B and Latvia. Both of those cases have been analysed by the Court of Justice as involving substantive rights. And so what we know is that the right to the protection of communications data under the e-privacy directive is viewed as a substantive right, and also the right to data protection in B and Latvia is viewed as a substantive right. In contrast, procedural cases like Inter-Environment Wallonie and A and fail to pronounce Flemish that we just looked at have been viewed as being procedural cases. Those are cases involving environmental impact assessment, where there's a duty to carry out some form of analysis before the substantive decision is taken, but it doesn't govern what the substantive decision ought to be. We suggest this case is clearly on the substantive side of the line, because it essentially raises the same type of issues as la quadrature and B and Latvia. The next issue is whether the ratio of those cases is a binding ratio in circumstances where the legal framework has fundamentally changed. is the ratio of those cases still a ratio which is binding in circumstances where a preliminary reference can no longer be made to the Court of Justice? Of course, the whole purpose of a preliminary reference is that it's a mechanism for ensuring the uniformity of EU law and uniformity in the application of EU law. Even without the regulations being in place, we suggest that for the ratio of those cases to remain good and relevant, you have to be applying it to the same legal regime. So even without the regulations that we looked at, the appellants are far from persuaded that la quadrature is binding on ordinary principles of precedent, because we're now dealing with a separate legal regime in which a reference to the Court of Justice cannot be made, and the Court of Justice cannot determine the issue. And because Brexit has occurred, the imperative, which the Court of Justice rightly emphasises, of maintaining control and consistency over the application of EU law no longer applies in the same way. I mean, going back to the logic of it, the coherence and the integrity of EU law analysis can't quite sensibly apply in circumstances where the current status of the law is that no reference can be made to the Court of Justice, and as a result of Brexit having occurred. It's a bit like a binding decision on a former legislative regime. Because the legislative regime has now changed, the analysis in those decisions can be regarded as persuasive, but no longer binding. So we say, first of all, that this case doesn't involve, in truth, a departure from binding case law at all, for this court to adopt the approach which it took in Liberty, and which was proposed by the Supreme Court in Chester. But even if it did...
But if that is so, aren't you cutting off the branch on which you're sitting? Because you need the jurisdiction in La Quadrature in order to suspend in the first place.
Well, there's no doubt that the jurisdiction exists. The only issue on which there may be binding authority which is troublesome is who has the jurisdiction to exercise.
Yes, when you say there's no doubt the jurisdiction exists,
Yes.
I thought the logic of the position you've just been submitting is that there is a doubt whether it exists, because the principle exists only for a particular purpose, namely the maintenance of the integrity of EU case law. That purpose has gone away, and the framework which underpins it has gone away, so there's no need for the jurisdiction to suspend to exist.
Well,
isn't that where your argument goes?
No.
I know it's not where you're intending it to go, because you told us you think the jurisdiction exists, but I haven't quite understood what its basis would be if you were right about this.
There's no doubt. First of all, there's no doubt that the jurisdiction does exist in a general sense. So the Court of Justice has accepted that in a so-called procedural case, even a national court can take this step. So, for example, in a case involving environmental impact assessment, that subject to its strict test being satisfied, they have no difficulty with the national court saying that they're not going to disapply a national instrument or a national decision for a particular period to allow a breach of EU law to be remedied. Equally, the Court of Justice has said that it has power to suspend disapplication in a case where it is seized of the issue, but it thinks that a national court should not do that because of its concerns about the coherence of the
Yes, but another way of putting it would be that for precisely that reason, the jurisdiction exists because, in the interest of legal certainty, and in circumstances where there are not lots of other lots of other states who are going to, with whose law there should be no inconsistency, it might be said that the logic of the ratio of la quadrature is that when transposed to the current legal framework, the only relevant court, which is the court which is the relevant court as defined, the domestic court, should exercise the power which for a particular non-applicable reason had previously only been exercisable by the CJEU.
And that's, but what we say is that the reason why that power has only previously been exercised in La Quadrature for the first time, it was said it can only be exercised by the CJEU, is because the Court of Justice didn't want that power to be exercised by the courts of member states, because the court was concerned about the coherence of EU law. And in the context of, for example,
I see where you're going, yes.
in the context of communications data, whatever one may think of that decision, one sees the practical logic of it. Because let's say, for example, Vodafone has operations in numerous EU law countries, EU member states. Not just the United Kingdom, but operations throughout the EU. If a court in one member state starts, first of all, imposing requirements of EU law, but also suspending the application of the disapplication of incompatible provisions of domestic law, it rapidly becomes pretty much impossible for a commercial entity operating across the EU to comply with those laws. And also, the application of EU law becomes fundamentally different in each member state, which undermines the purpose of a single market and all the other things that the EU is trying to achieve. So the Court of Justice is saying, when it's a substantive matter, it can be done, but only we are going to do it.
So I think what you're saying is that the imperative of legal certainty is what drives the allocation of the jurisdiction to the CJEU rather than the national court.
Yes.
And that doesn't apply post-Brexit.
Yes.
It may have some impact on which courts within our jurisdiction should exercise that jurisdiction. It might not be all the relevant courts, perhaps, but
It does, and it doesn't go to the existence of the jurisdiction as a whole. So there isn't any doubt in the Court of Justice authority that that jurisdiction exists and ought to exist. What they're saying in La Quadrature is that we think in a certain class of cases, we, the Court of Justice, should be the only people to exercise it. And that's for reasons relating to legal certainty. And
Mr. Jeffrey, can I just ask you a supplementary question on this? You began this line of submission by saying that even leaving aside the 2020 regulations, and I understand that. I understand that the logic of your submission, if I may say so, is entirely coherent. It doesn't depend in any way on the existence of the 2020 regulations. But would it follow then that this jurisdiction could in principle be exercised in the domestic legal order by a court or tribunal which is not one of the relevant courts listed in the 2020 regulations? For example, a first instance tribunal of some sort. The logic would appear to lead to that conclusion. Is that right?
yes, as a matter of pure binding precedent,
Yes.
that would be correct. As to whether that would be advisable and appropriate is another question. And that's because a decision of the Court of Justice on any view has substantial persuasive effect and continues to do so. And a lower court, for example, a tribunal or a first instance court, will exercise much more caution before departing from analysis which, although it's not technically binding as a matter of law, is nonetheless persuasive. But yes, I accept the logic. The logic of the argument is that if it's not binding, then it's not binding on anyone.
Another way of looking at it might be that what you're describing, the process of reasoning which you have outlined very, very helpfully, if I may say so, that the logic of the ratio of la quadrature no longer applies when the legal framework has fundamentally changed. It might be said that that actually is a good reason for departing. In other words, then you come back into the legal mechanism created by the 2020 regulations.
Exactly.
It might be, I don't know, it might be thought better to take that route because that would mean only, for example, this court
Yes.
or the Supreme Court and the other relevant courts listed would be able to exercise this. And I don't know, it might be said legal
I'm
certainty is
probably raising this point as to whether that part of La Quadrature is strictly binding ratio as a matter of legal purity. The court, of course, doesn't have to go there. You can just simply say that the regulations are satisfied and the test in the 1966.
It's not quite, and this may not matter, we've got to find a sensible answer, but that's not quite the kind of case which, as I have always understood it, the regulations directed to. This is really adjusting a uncontroversial principle of retained EU law to a situation where you can no longer make a reference. Probably you could do it as a matter of language, but the feel of the 2020 regulations is more where you're changing a substantive principle of retained EU law. So I'm quite attracted for myself by the first way you were putting it, which is that would this be an acceptable paraphrase? The retained principle of EU law is that there is a jurisdiction to suspend. The bit that doesn't carry over because the reasoning supporting it has disappeared is that jurisdiction may only be exercised by the CJEU itself. On that basis, as you started, we don't need the regulations. Yeah. The only consequence, which is perhaps troubling, but I'm not sure I'm as troubled by it as my lord is that it must follow from that the jurisdiction is exercisable by the first instance court. But very often, tribunals may seem a bit odd, but classically, we're talking about judicial review, where this is most likely to come up, that will mean the High Court. We may well be in a situation of some urgency, one often is in these cases. It would be odd if the High Court didn't have the power to make a power of suspension, and you had to wait for an appeal, query against what? There might be no appeal against the substantive order, to get to a situation where you found you had a court with jurisdiction to suspend. So speaking for myself, I would not be embarrassed by the logic of your primary position.
Yep.
But I'm thinking aloud, as you can tell.
No. On what the test is for identifying the ratio of la quadrature, we would probably put it slightly higher than my lord has just put it to me in argument. What my lord said was the legal reasoning of la quadrature has gone, and for it to not be ratio, it probably has to be something slightly more than that, and it's actually the statutory framework in which it's applied, because a reference can't be made.
No.
I think we respectfully agree that it's because a reference is no longer possible, and because that reservation of jurisdiction by the CJU cannot any longer be exercised. That the legal framework has fundamentally changed, and therefore one has to consider, well, who should exercise that jurisdiction, which undoubtedly exists as a matter of retained EU law.
But the principle that underlies the reservation of the jurisdiction to the CJEU is, even if it's not part of the ratio, a transferable thing, so that it might be said that a court which isn't a court of record or a tribunal should not exercise the jurisdiction, because that way leads the sort of legal chaos and inconsistency that the CJU was concerned about.
It is, and that's a sensitive issue analysis, because the Court of Justice, of course, often considers preliminary references from first instance courts, and those first instance courts may be about to grant relief. And so that jurisdiction, which is exercised by the Court of Justice, is exercised in aid of the decision-making of first instance courts, as well as appellate ones. And so it's a complex issue as to whether or not a first instance court should be completely banned, as opposed to being cautious from exercising that jurisdiction.
Mr. Jeffrey, can I just ask you in that context, correct me if I'm wrong, because I understand it continues to be the case in this legal system that bodies such as the Employment Tribunal may well, where retained EU law is still operative, may well be under an obligation, is this right, to disapply even primary legislation?
Yes.
In principle. Yes. So they could get to that stage of a case. But, query, do they have the power to suspend what they're doing? Because there could be all the policy considerations that have led courts to take the view that there should, in principle, be this jurisdiction to suspend, like chaos, criminals may go free, and that sort of thing. In principle, that could be a problem, could it? Even in a first instance court or tribunal. It might be said, therefore, that there would actually be quite a neat symmetry if, now that we're no longer in the EU, and that tribunal or court can no longer make a reference to the CJEU, that it itself should be able to do what the CJEU used to be able to do. Does that make sense?
Yes.
And that, as my Lord says, doesn't in any way turn on the existence of the 2020 regulations.
No, it doesn't. And I raise this because I think the logic of the position and the logic, when you read La Quadrature, and the fact that the analysis in La Quadrature is based on the existence of the availability of a reference, and that legal underpinning, and that legal framework for that analysis has now gone in respect of the United Kingdom, but retained EU law remains in place, at least in certain categories of cases, then we suggest the inescapable logic is that that is no longer binding ratio, the allocation of which court gets to take that decision. And there may well be all sorts of reasons for great caution to be taken by first instance tribunals in granting very extensive relief, including relief which has an effect on the application of primary legislation, but it doesn't render it impossible. And of course, tribunals come in all sorts of shapes and sizes. This type of issue could, for example, easily arise in, say, the Investigatory Powers Tribunal, where issues of EU law are commonly litigated. So that's the pure legal argument. There is, of course, the alternative route of the regulations. And we say, if necessary, the regulations are available and they do work. Although they can, of course, be used to achieve a substantive departure from a line of authority in the Court of Justice, if this court or another relevant court is satisfied that line of authority has gone wrong, and the test of the 1966 practice direction is satisfied, it could also be used to achieve more minor adjustments of fixing problems which arise as a result of Brexit, as a result of a reference no longer being possible, that remedial discretion still existing as a matter of EU law, and how that has to be worked out in practice when the court takes decisions and grants relief. And what we would emphasise is that the result which we're contending for does actually achieve the intended basic result of the Court of Justice case law, which is that there is a discretion in appropriately exceptional cases justified by strict necessity to grant a limit on relief. And it's simply working that out in a world in which a reference is no longer possible. Those are the appellant submissions on the issues of principle. The issue then is how it's to be applied on the facts of this case. There's sometimes a question in these cases as to whether the order is one for disapplication or is a declaration. I'm not sure it makes much of a difference on the facts of this case, because the declaration here would be the declaration that the immigration exemption is not of any legal effect and can't be relied on as a basis for processing personal data. And presumably, in any event, the government is going to repeal the current immigration exemption and replace it.
It's very common, we all know, in cases of this kind for, I suspect it's almost certain normal practice now, simply to make a declaration on the basis that the government will recognise its binding effect. However, we've been talking about disapplication. Translated into common law terminology, that would be a quashing order, wouldn't it?
That would be
a quashing order disapplication is a concept we all sort of come up through from an EU background. I don't think you'll find it anywhere in the rules.
No.
So what is it in practice a quashing order?
Well, there is an interest. No, it's not. And there's an interesting.
So either.
No, it's an important question actually. It's an interesting, almost philosophical issue about what the nature of disapplication is, because of course, in a country in which there is parliamentary sovereignty, the court has no power to grant a quashing order in respect of an act of parliament, and the courts haven't done so. But the courts have granted orders disapplying the effect of provisions in acts of parliament. And what that means is the court is essentially deciding that the effect of what used to be the European Communities Act 1972, now the EU Withdrawal Act, read with the GDPR, is that this provision in primary legislation is to be treated as having been impliedly repealed.
So the terminology of disapplication should be embraced because it recognises that this is a rather peculiar creature, even though I don't think, as you've accepted, it's not to be found in the rules or indeed in the statute. But that's the best label for what is happening in this type of case.
All I'm saying is that my client's not particularly fussed about the label.
No, I understand, but we want to
case.
decide what label to use and why.
Although we would go further than simply saying the government will respect a declaration, because any declaration the court makes will have an effect on private sector entities as well, and the court will simply be stating what the law is more generally, and it will be applicable to everyone. So any private sector body that chose to, for example, purport to rely on the immigration exemption would of course be acting unlawfully as well.
Yes, as you say, to some extent it's a philosophical debate, but it's nevertheless, certainly speaking of myself, important constitutionally, because speaking for myself, courts in this country have no power. It seems to me we shouldn't really talk about order of discipline, because you can talk about the fact of disapplication. Of course, employment tribunals, we know from old cases like Marshall, may well have the obligation, in fact, to disapply. What they're doing there, in truth, is stating what the law accurately is, so that something which looks like the law isn't in fact the law, because it's superseded or displaced to the extent of an incompatibility by a superior legal norm. All of that I understand, but I personally am very uncomfortable with any talk of order of disapplication, because that is, in fact, to say we're quashing an act of parliament. Can't do that. That's why it seems to me, in cases like the EOC case, the House of Lords was very careful to say that although certiorari was not available, nevertheless a declaration was available. And so the remedy, when it's a judicial review case, it seems to me that the appropriate language, importantly, is called a declaration. Nevertheless, you're quite right, Mr. Jaffe, if I may say so, to point out that a declaration is binding. And again, in the Liberty judgment, we tried to set out the history of all of this, and we made it clear that it's not simply something that, as it were, as a matter of courtesy, the government chooses to comply with. When we make a declaration, we are making a binding declaration of what the law of the land is.
That's right. I respectfully agree with that, and that was what I was attempting to say by what the court is doing when it sometimes calls things disapplication. Whether they should or not is another question. Is it simply declaring what the law is, and the reason why the court is not giving effect to the provision of a certain act of parliament is because formerly the European Communities Act told the court not to, and now the European Union Withdrawal Act tells the court not to. So the court is declaring what the law is. It's not saying that a law made by Parliament is of no effect. It is applying the law as a whole. And of course that was always the case, even before Brexit. That was the position as to how EU law took effect in a country in which Parliament is sovereign.
Thank you.
So it's common ground between the parties that it would be appropriate to suspend at least part of the relief which the court grants for a limited period. The question then is, until what date and on what terms? The first point, which is common ground, I think, is that there should be a reasonable opportunity given to the respondents to put forward an amendment to the immigration exemption so as to comply with the requirements of Article 23 of the GDPR. But it's also not proper for that to be open-ended, and that's because the court is exercising a fairly unusual and exceptional discretion to, in effect, permit the continuation of what it's concluded is unlawful conduct. And the context in which that occurs is, as the Information Commissioner has pointed out in her submissions, many of the victims will not know of the unlawful conduct occurring, and they are especially likely to be unable or poorly placed to make a complaint about the use of the immigration exemption. Now, in this case, the immigration exemption was commenced in May 2018, and this claim was issued in August 2018. So there's already been 3 years of unlawful conduct. This court gave judgment at the end of May. That was over 4 months ago. Some considerable time has already passed since that judgment. No draft legislation has been published yet. The government has not even disclosed in its 2 witness statements even an outline of its proposed policy. What is proposed by the respondents is that if the court is going to make an order setting an end date, that end date should not be until the end of April 2022, which is a further considerable period. We suggest that such a period is not strictly necessary, and in practice it would actually undermine the binding effect of the court statement of the law. That's the first point. The second point is that we suggest it's essential for the court to actually set a final end date by which the immigration exemption in its current form is declared to no longer have legal effect. In contrast, the respondents asked the court to only set a date by which a draft instrument be laid before Parliament, leaving it therefore open-ended as to when the unlawful conduct will in fact cease. We suggest that approach is wrong in principle. It wasn't the approach that was adopted in Liberty, and we suggest that's because the unlawfulness only comes to an end when the amending legislation, which would be a statutory instrument, becomes law. Now, of course, it is entirely a matter for Parliament when the government presents it with a draft statutory instrument, whether to accept it or reject it. But so long as a reasonable period has been given for that process, we suggest the court should set an end date by which its decision should be implemented. The third issue is what the date ought to be. As you've already heard, the respondent's proposal is the end of April 2022. We originally suggested November. I fully accept that given the date of this hearing and that nothing has been laid before Parliament yet, that's probably not going to be long enough. The Information Commissioner therefore has suggested the 31st of December of this year. We reluctantly accept that some additional time from what we propose will be necessary. 31st of December would be 7 months from the date of this court's judgment and is just under 3 months from now. Just by way of comparison, the time given in Liberty was just over 6 months from the date of the court's judgment. On any view, work must be highly advanced by now on the drafting of an instrument. And it's probably not for the parties or even the court to get too involved in parliamentary procedure beyond giving a reasonable opportunity for approval. But the 31st of December would enable the government to lay a draft before Parliament, before Parliament's autumn recess, which starts on the 9th of November, and then after the autumn recess, that would give a further month for Parliament to consider and approve the draft if it thinks fit.
In the Liberty order, we included a liberty clause to to vary. We gave the parties the opportunity to come back to us if the evidence demonstrated, in the end, that clause didn't have to be invoked. But what do you say about the principle of whether there could be a liberty clause?
The principle of a liberty clause is not in dispute. That would be a proper course for the court to take. The events of the last 2 years have shown that unexpected things happen sometimes. And I think the liberty clause was used in the liberty case in respect of the implementation steps.
I see.
The practical arrangements for setting up the Office of Communications Data Authorisation. Ultimately, the legislative regime was put in place on time, as I recall. Finally, we emphasise this is not a business as usual step. What the court is doing is it's reflecting the decision of Parliament to keep the UK GDPR in its EU form, and therefore that greater safeguards are required before a lawful exemption should be used. And so therefore remedying the unlawfulness is urgent. We suggest that 31st of December is sufficient and it isn't strictly necessary to allow any greater period of time. The final issue which arises on relief is the scope of the suspension and whether it should cover only the public sector or whether or not a suspension should be granted in relation to the private sector as well. The appellant's position is that time should only be allowed to address practical problems which have been demonstrated to exist by evidence. And the respondents have not adduced any evidence of any difficulties that would be caused for the private sector in an immediately effective declaration. And in the absence of any evidence, we suggest that the ordinary principles ought to apply, that the court should simply grant declaratory relief, such other relief as it thinks fit, and the unlawful action should therefore stop. Now, it's right that a case has been put forward for the continued temporary use of the immigration exemption by the government. But in the absence of a reasoned case, supported by evidence, as to why it's necessary in the private sector, we say the court, any suspension granted by the court should not extend in that way. Now, my learned friend, acting for the respondents, put forward, I think, 2 responses to that submission, which are set out in their reply submissions, which are on page 97 of the hearing document. Start at 96 and the relevant parts, sorry, to page 97. And at paragraph 4 of the submissions, what the respondents say is that such an approach would cause considerable uncertainty, requiring any person affected by or using the legislation to read not only the terms of the Act, but also whatever limited qualifications are meant to be read in by order of the court, and that would be a recipe for confusion. And those are submissions that the Information Commissioner agrees with. Well, first of all...
Can I just ask, Mr. Jaffe, I should have looked for it. Have you supplied a draft order as to how the distinction would be?
No, the parties haven't actually produced a draft order. We probably should have. I'm sorry about that.
It would just focus one's mind on exactly how you define the distinctions which you're arguing for. But anyway, so be it.
Can I deal with that? What we propose is to use the definition in the Data Protection Act 2018 itself, which does distinguish between public bodies and other bodies. That definition is in section 7, which we handed up as a separate document. So section 7.1 defines public authorities as being, amongst others, public authorities as defined by the Freedom of Information Act 2000, so it cross-refers, subject to various slight changes, and the there is a schedule of public bodies in the Freedom of Information Act which includes all government departments and secretaries of state. So we say in terms of legal certainty, there is a readily available definition within the same relevant legislation which can be taken. If anything, that definition is overbroad, because in truth it's probably only central government that needs to continue to use the immigration exemption, but for the purposes of certainty and simplicity, that seems to be a sensible source of the definition. The idea that this would cause confusion is one which we say with respect is not right, because it will be necessary to read the court's order in any event. And public and private sector bodies will need to do that before applying the immigration exemption in order to understand what the legal position is. And if, for example, Parliament were to reject a proposal which is put forward in draft legislation by the government, then everyone would still need to read the court's order before relying on the immigration exemption in order to understand they were unlikely to be able to successfully do so. It's inevitable in a system in which primary legislation may not be given effect as a result of a court's decision, that it will be necessary not just to read the text of a statute, but also to read judgments and orders of the court relating to that statute. That's been the case since at least fact attainment. And also, of course, the test is one of strict necessity. It doesn't come close to a requirement of strict necessity to say that we must maintain an unlawful arrangement and permit the private sector to use the immigration exemption because of the risk that people might be confused as to whether or not they can still use it. To the contrary, we would say that a requirement of strict necessity means in practice you have to tailor the relief to the actual problems, not grant a blanket suspension when only a limited one is in fact required.
On your submission, would there be any suspensory effect of our declaration vis-à-vis the private sector? Because normally a declaration by a court is simply stating what the law is and always has been.
Yes.
So you'd go that far, would you?
Yes. There is no evidence that's been put before the court, and every opportunity has been given, that the private sector would suffer any difficulties by the immigration exemption being declared to be unlawful straight away. And the second reason that's put forward in my learned friend submissions is at paragraph 5 on page 97. In 5A, it's accepted there is only very limited evidence on the extent to which private persons rely on the exemption, but the respondents consider that private persons are likely to find reliance extremely difficult. Thus, the appellant's concerns are likely to be more theoretical than real. Now, what is said is there's only limited evidence of the extent of private sector usage. It might be more accurate to say there is no evidence which is before the court, and if there is such evidence, I'm sure it will be drawn to your attention. But the respondent's submission that because private persons are likely to find reliance on the exemption difficult helps the respondents is a strange one, because if the private sector, on the government's analysis, are not using the exemption, then there's no problem in removing it immediately, and there's no justification for a suspension. It certainly seems to be accepted that no case has been identified in which its immediate removal would cause a problem. I mean, as it happens, the appellants are perhaps not quite as sanguine as the respondents about the private sector use of the immigration exemption. In the court's judgment at paragraph 15, the court summarised the evidence of errors which had been made, for example, in relation to people refused permission to open bank accounts because of incorrect information about their immigration status. The appellants are concerned about the use of the immigration exemption by the private sector, in which there may be real and immediate harms. And unless some evidence can be put forward as to real problems which require the maintenance of the exemption, we suggest that declaratory relief ought to be given straight away. And it's also important to recollect that the vice of the current immigration exemption, as the court found, is that it is overbroad and it doesn't contain safeguards and controls to restrain its use in practice. And so leaving something in place which can be used in an unknown and undefined way by the private sector in a range of situations creates risks, and they create risks of improper conduct. Now, sometimes it may be said that the requirements of the public interest are such that we're going to give a limited time to the government to fix those problems. But where the risk of harm is unknown and open-ended, and no case has been put forward as to why the public interest requires the maintenance of that position for now, we suggest that any suspension of the court's relief ought to be limited to the public sector only. Now, the final point made by my learned friends is at paragraph 5b of their submissions on page 97. It was said at 5b, and this was in relation to the appellant's original position, that even public sector use ought to be limited in certain ways to specific use cases, namely disclosure of entries in the warning index held by the Home Office and tipping off information. Now, the response the respondents give to that is that if the use of the immigration exemption was expressly limited in that way, that might itself lead to someone being tipped off. Now, we accept that's a fair point, and so we accept that the court's relief ought to be more general and permit public sector use generally, to avoid that unfortunate consequence. So, ultimately, my lords, what the appellants propose is the end of this year for the public sector, as defined in section 7. This is a case in which also the appellants have always said since the outset of the case that they accepted that any relief that the court would grant, if their claim was successful, ought to be properly and carefully tailored. These appellants have never had any interest in causing harm to the public interest. Their concern is that a properly safeguarded exemption exists, which is controlled. But the harms of delaying relief don't only go in one direction. And that's because a long delay, which is not justified by evidence in implementing a decision of the court, itself risks undermining the law as declared by the court, which is, of course, the law made by Parliament. Because what the court is doing when exercising this unusual and exceptional jurisdiction is it's deciding for a temporary period in the public interest not to implement the law as Parliament wishes it to be. And so the balances do not only go in one direction. And that is why the Court of Justice, when contemplating a jurisdiction like this, has always emphasised that the test for its application is a strict one indeed. May I just turn my back for a moment? I think I've covered most of the matters I need to. Unless I can assist the court further, those are the appellant's submissions.
Thank you very much. We don't actually have Mr. I forget, I wasn't listening when you introduced counsel. We don't have Mr. Knight on our counsel sheet, but he is here, hiding behind a mask. Mr. Knight, do you want to make any submissions?
I would, my lord, very briefly. I'm content to go after Sir James or before him.
If that's the order you'd arranged.
I don't think I've arranged, but I don't mind either way. Let's put it that way.
Seemed to me slightly more natural to have you now, but you're happy with that, are you, Sir James?
In your hand.
Very well.
And particularly given the importance of your hearing from Sir James, with more than enough time, I was going to be very brief in any event.
Yes.
you have written submissions from the Information Commissioner at page 88 of your hearing bundle, and I'm not sure I have a great deal to add to those orally. I certainly I'm not going to just stand up and read them out. On Mr. Jaffe has taken you through the legal principles in great detail. I'm very grateful to him because I think that leaves very little for me to add. We agree, as we did in writing, with the position that Mr. Jaffe sets out in relation to the law and why the jurisdiction now falls to this court and cannot be exercised, cannot sensibly be said to be exercised only by the Court of Justice. On the debate that your lordships raised with Mr. Jaffe about how that might work, the Commissioner's position is that the correct construction about the allocation of the about the court saying that it was for it alone in substantive cases to suspend relief was a principle of allocation and not creation of the jurisdiction. To answer the question raised by my Lord Justice Underhill and answered, I think, in the question from my Lord Justice Warby, on the practical question, which may or may not matter a great deal as to the level of the court, which can exercise the discretion to suspend relief, and whether or not this is a matter of binding ratio or a matter for the 2020 regulations. Again, it seems in my respectful submission that Mr. Jaffe's position is the correct one, that on reflection, the most appropriate construction of the Court of Justice case law is that the binding ratio does not strictly apply in this context, and so one doesn't get into the 2020 regulations. And for the Commissioner's part, we would share the sanguine view of my Lord Justice Underhill about the effect of that, and that it is in principle appropriate for a first instance court to consider whether or not suspension of relief is appropriate and made out in the particular circumstances, and isn't a matter which should be reserved only to the appellate courts. I observe in passing, of course, that in the Liberty case, the divisional court was sitting as a court of first instance on a claim for judicial review and took that approach. Of course, it will be right, as Mr. Jaffe said, that lower courts and tribunals may need to think very carefully about the wisdom of exercising that discretion, but that's the same in the Ahmed type cases that were mentioned in passing at the very outset, where one's looking at where one is thinking about questions of relief as applied to secondary legislation. Lower courts and tribunals have to confront those questions and think very carefully about them. And as we say in our written submissions, although the precise formulation of the test in the retained EU law context is one specifically framed around the test of strict necessity, and we agree with that. In substance, the question being asked by the court and the test being applied by the court is much the same in the retained EU law context as it would be in the common law context, because one is asking the court to do something out of the ordinary, to as Mr. Jaffe says, permit an unlawful state of affairs to continue for a short period of time in order to avoid harm to the public interest. And that's obviously an exceptional course and can obviously only be justified where it's necessary to do so and for the shortest possible time. And in reaching that decision, a balance has to be struck. And the Commissioner entirely agrees with Mr. Jaffe's submissions that the factors do not go only one way. And the bulk of my written submissions from paragraphs 8 onwards are set out a number of factors which go to that balance which have to be struck. And they do go both ways. And just to pick up a few points from those submissions that my learned friend hasn't particularly made or focused on, we say, and I respectfully say it's important, that the data protection regime is a hugely significant and wide-ranging piece of legislation. it applies to almost everyone in different ways, it's one of the perhaps the most pervasive pieces of legislation on the books, and that's important to bear in mind. Going both ways, and particularly from a legal certainty point of view. So if one takes the example Mr. Jaffe raised of the Merchant Shipping Act, and that sometimes declarations have to be made that the law is to be disapplied. The effect is a disapplication of the law, as Singh's point in that respect. The Merchant Shipping Act was a piece of legislation with the relevant provisions of it, which had a very specific impact in a very specific area, with quite a defined group of persons who would be affected by that. That's not true in the case of data protection legislation. It is very wide-ranging and applies to almost all public authorities and businesses, and indeed individual citizens, whether as data subjects or indeed data controllers. And so it's especially important in that context, in the Commissioner's view, that the government have a reasonable period of time in order to ensure what appears to be the law of the land on the face of the legislation aligns with what this court has said in its judgment to be the proper law of the land and the proper interpretation of that law. Where there is a disconnect between the two, there is a much greater risk of confusion and uncertainty than might be the case in other areas. And that's an important factor in the balance, and it plays in the balance as to the period that the government should be permitted. But as we also say, that must mean the corollary of that is that period should be as short as possible. Sir James will no doubt make clear the basis on which the period of time sought is to be explained, but the Commissioner's instinctive reaction to a period that is an end point of the end of April next year is that is far too long. The reasons that, as we understand it from the witness evidence relied upon by the respondents, principally rely on general timings for affirmative resolution statutory instruments. So it would ordinarily be the case that there'd be 6 to 8 weeks for Parliament to consider them. There'd ordinarily be a particular period in which it goes to the Joint Committee on Statutory Instruments. Ordinarily, there would be a period of 21 days between the legislation being made and coming into force. And I don't disagree with any of those things in the ordinary course, but this is not an ordinary situation. This is a situation in which just amending legislation is required because of a judgment and order of this court. And if there is any situation in which those timescales might need appropriately to be reduced, it is that sort of situation. I know the point is also made in the government's witness evidence about parliamentary recesses, and perhaps one point of observation, although I wasn't involved in the litigation, is that the period of 6 months granted by the court in the Liberty case started from its judgment in April, running through to November. An obvious point of contrast is that a significant portion of that period would have been when Parliament was in recess over the summer, and that didn't prevent the court from setting a relatively tight timetable. So, pending, of course, what my learned friend says, in principle, the Commissioner thinks it is extremely important that a finite date be set, and that at the moment, at the end of the year, appears to us to strike that appropriate balance. Lest the respondents continue to rely on it, we don't. The Commissioner's submission is that relatively minor factors, such as the need for the respondents to train their staff and so on, and alternate systems, should be given little or no weight in the court's balance, particularly where, as we said, paragraph 14 of the submissions, the respondent's case before you on the substantive hearing was that the safeguards are already set out across the wider legal regime, and so in principle this shouldn't require too much of a systemic or training change. Otherwise, on the question of the point of difference between the Commissioner and the Appellants is whether it is a good idea and whether it is justified to issue different relief as regards different categories of controller. And the Commissioner's position is that that would be an unwise idea. It would be an unwise idea practically, and indeed it may be an unwise idea constitutionally, because, at least to some degree, it involves the court rewriting the legislation, necessarily so, because on the face of the legislation it applies to all controllers, and the court will be writing into that legislation, in effect, through its declaration, that when it says that, it doesn't mean it. And that is precisely the sort of exercise that the court warned against in both Chester and in Liberty. It's a rewriting of the statutory scheme which is beyond the proper constitutional function of this court. But just as importantly, it creates confusion and legal uncertainty. And I quite accept my learned friend's point that, well, if no amending legislation is passed, the provision will have to be disapplied, will be the subject of a declaration and therefore in effect disapplied. And that's right, but one is thinking about the balance of interests at this stage. If it is unclear on the face of the legislation that it does not in fact apply to a particular category of cases, and it is unclear to the users of that legislation what that category is and when that might apply, that is unhelpful. And it is unnecessary in circumstances where, at least in my submission, the court is going to set a short timescale for the provision generally to be remediated. I think that covers the points in short summary that we made in writing. I certainly, as I say, I don't want to repeat everything, and I don't want to repeat what my learned friend Mr. Jaffe said. So, is there anything I can assist the court on the Commissioner's part?
Thank you very much, Mr. Knight.
I'm grateful.
Sir James.
My Lords, there doesn't appear to be any dispute amongst the parties before the court that post-Brexit the court can allow the state a reasonable time to correct and deal with incompatibility with EU law of the kind that has been found in your judgment. And I put it that way deliberately because although we do not quibble with the reliance by my learned friend Mr. Jaffe on the references to strict necessity in the EU case law, there's nothing terribly surprising or interesting about those, and nor does anyone seek to suggest that those statements conflict in some way, or indeed in any way, but with the approach that this court, that the divisional court, adopted in the Liberty case. And in the Liberty case, that language, taking into account the underlying unlawfulness, the need to correct it with some urgency, etc., the language that was still used in Liberty was the language of reasonableness in terms of the amount of the time. You see that in paragraphs 76, 94, and 187. I'm sure there are other places, but those three jumped out at me. There is a question about precisely how that jurisdiction is based and which court can exercise the jurisdiction. It might be thought that the initial answer to that is that there are two rather separate issues which may or may not engage the concept of ratio in La Quadrature. And the first of them is there a jurisdiction under EU law to suspend this application, in effect? And the second of them is, if there is, who should exercise it? No one, I think, quibbles with the idea that it is still part of binding EU law that there is a jurisdiction to suspend this application. So the question is what happens post-Brexit in relation to the second question, namely which court should exercise it. Now I can quite see that the route by which you go may or may not have an impact on whether or not you end up in the regulations or you end up not in the regulations for that purpose. And there's, I hope you will understand, there's a degree of nervousness on this side of the court about precisely how that issue might be resolved. I haven't got instructions from a source at least where I would naturally seek them in relation to an issue of that kind, which would probably be from the Cabinet Office, as to whether or not anyone has any particularly strong view in relation to that.
But it is something you may say, strictly speaking, we don't have to decide it because on either route we have the power.
Quite.
But I think it would be rather unsatisfactory for this court, when exercising the power, not to identify how it arises.
My Lord, yes, you don't have to. You don't have to
the
address.
Cabinet Office, some agreement.
I'm really hoping not, otherwise I'll have to react to it. You don't have to worry about the jurisdictional basis for that. This is just a question of who exercises it, and on any view, through either route, you can. I mean, I can see in principle, I confess, an initial attraction to saying if you've got a court which has the power to disapply, it might be a great deal more satisfactory in principle for that court also to have the power to suspend a disapplication with all the routes of appeal that might flow from that. But of course, there may be a degree of nervousness about.
Well, I see the degree of nervousness, but it's, at the moment, I think it's somewhat incoherent. Supposing it is a first instance court, and it is a plain, assume a plain case for disapplication. Sorry, it's a plain case for suspension of disapplication. Say, well, I absolutely hear what you say, Sir James, for it might be you, but I'm afraid we can't do this. You'll have to appeal. And then what would you be appealing against?
My Lord, that's the force of the point that I was recognising.
Yeah.
But I just don't know whether there are other arguments which government would wish me to mount against that.
On the face of it, it's more likely to be beneficial to you than not.
I entirely agree, which is why the initial explanation was as it was.
Well, you're being very frank, Sir James.
My invitation, in short, is
no doubt
set out the options, but don't go there, please.
Yes, I see. Right. Well,
and if I have to argue this in front of the first-tier tribunal in some context, then that's what I'll have to do. I know that will be coming before you again. But as I say, we haven't fully addressed this in writing, either party. I can see quite why it arises. You have my initial inclination, if that's of any assistance to anyone. But I'm just nervous about committing finally to a position on that until I have proper instructions.
But sorry, we perhaps rather too fast. You're clearly being agnostic about the route, but you are clearly accepting that we have the power by one route or the other.
I am.
Yeah.
So in a nutshell, then, we all agree, essentially, with the basic analysis that Mr. Jaffe very helpfully outlined for everyone in the first hour of this hearing. That's a matter of common ground, at least between the parties. It's not a criticism, because it was helpful to have it outlined in the detail and no doubt assisted the court. But that's where we are. So we start from the position in which there are really two issues for you. One of them is nature and extent. I'll come back to the precise form of order in a second. But nature and extent, and that now has narrowed itself to whether or not it's public and private or not. There was an issue about warning indexes and tipping off and all of that, but that's gone. And then perhaps most importantly, reasonable time. On nature and extent, just to reverse the order of the points, because I can deal with that very briefly, we respectfully agree with everything that the Information Commission has said in writing in relation to that point, and everything that my learned friend Mr. Knight repeated crisply and orally. In essence, we agree that there are essentially the two aspects to it. One of them is the constitutional one, better by far to allow this sort of decision-making to be made by Parliament, respect the fact that Parliament...
Can I just explore that for a moment? Is there really a constitution that... We start from the point that the law as apparently enacted does not actually correspond to the law. That obviously has all sorts of constitutional aspects, but that's all been decided and is constitutionally correct on the basis we all accept. We'll then simply have a separate question whether to suspend the effect of that decision for pressing reasons of the public interest. Take a case which may be rather starker than we've got now, where it is absolutely clear that there is a particular but limited area of the operation of the law where there is a strong public interest in suspension, but not as regards the rest of the application of the law. I don't see that distinguishing between the two gives rise to any constitutional question. It's not a question on which you expect Parliament to express a view. It's a question for the court about whether to exercise an exceptional power in the public interest. We often have to decide matters of the public interest.
My lord, of course you do, and of course technically that is right. I suspect that the constitutional point is a slightly broader one, which is that this whole set of issues, with the benefit of the court's judgment now before it, is going to have to go back before Parliament for it to make a range of interconnected and quite complex decisions about how to set up, maintain, amend and alter this area of legislative policy. They have so far decided, albeit now that the court has concluded that the safeguarding regime that exists doesn't exactly correspond to the form it should do under EU law. And the constitutional concern, I suspect, is simply the broader one, which is that when considering those issues, it's proper for the court to respect the current setup of the law, which basically allows for an immigration exemption to be applied both by public and by private people, and to allow those judgments all to be reconsidered by Parliament as a compendious whole. I mean, there is an aspect of the practical, which is the second point I was going to make. There is or emphasise, there is an aspect of the practical which is also potentially has some bearing on that, which is that, well, perhaps 2 points as a matter of practicality. One of them is that it might be thought to be a great deal more desirable for the law to be changed and the face of the law to be changed once and properly, particularly when you're dealing with the public-private divide, so that private people can see. Of course, my learned friend is right technically. The court judgment has to be read alongside, whatever order you make would have to be read alongside. But there is an intensely practical aspect to this, particularly from the perspective of private people seeking to rely upon the immigration exemption, which is that it's a great deal better, it might be thought, for the things that they would have to do before they could rely on it to be set out sensibly on the face of the legislation in one document, rather than them having to try to, as it were, lawyer their way through it. And the second practical point to note is that although everyone is proceeding, my learned friend is proceeding on the basis that there's nothing on the private use of this in evidence, and although we've said we think it would be very difficult for private people to rely upon, it's a query how much the issue will actually arise, those private users are not before the court. You don't have full and complete evidence of the circumstances in which there may be private reliance upon the immigration exemption, and there may well be aspects of the public interest that will be protected by such reliance. So for all of those reasons, we do respectfully submit that there's something of an overlap between the constitutional concerns and the practical concerns, but that both aspects are legitimate aspects that can be relied upon by us and indeed by the Information Commissioner, and tend in favour of doing this thing once. So that's all I wanted to say about scope and scale. So far as reasonable time is concerned, of course the position is that, and I accept, that matters have to be done with a degree of urgency in the light of the court's finding, and they've been taken forward on that basis. But it is important, particularly in the light of the fact that there are, as the court has, I think, acknowledged in its judgment, there are potential washovers into the structure, form and nature of other exemptions under the DPA of similar structure. There may be distinctions between them, but it's important that those should be considered. The matter's taken and will take some time and has got to be resolved carefully. There are important elements of policy that need to be thought about. That is one. So too is the precise form in which amendments are made. So too is the interrelationship between amendment on the face of regulation and what can and should go into guidance, and if so, how that guidance ought to be set up. I know you dealt with legislative measure and what that means, and there's some degree of flexibility in that, as the judgment has found. So all of these things need to be thought about with some care, and policy decisions made. Lots of different departments have been involved. It has taken some time to get to the place where we are currently at, as Mr. Prince's witness statements have indicated. Multiple departments involved, and as you are aware, at least a month and a bit probably of the period that has elapsed since the court gave judgment right at the end of May has involved August, and the whole of that period has also involved the multiple departments involved having other things on their plate.
They always have other things on their plate. They always have other things on their plate.
My lord, they do, but as my learned friend Mr. Jaffe rightly pointed out, unexpected things happen, and they have been peculiarly busy for reasons which I don't need to tell you over this period. That hasn't prevented work from proceeding, but everyone has been at full stretch trying to deal with lots of things, including in particular the consequences and the breakout from COVID. And that's obviously affected the two departments principally involved here, with the Home Office and TCNS. So we are where we are. The point I wanted to make about form is an important one. The intention is to use section 16 of the DPA. That enables affirmative resolution regulations to be made to amend primary legislation, in effect. And there is quite an important point which flows from that into whatever form of relief you ultimately grant. My Lord Justice Underhill asked my learned friend whether he was really asking for some form of quashing, whether in nature or form or not. And you need to bear in mind that the most likely form in which this set of changes will be made will be by retaining what is currently on the face of the primary legislation and then adding to it by way of amendment, rather than ripping it up and starting again and producing something completely different. So whatever form of relief it is to be granted, it should allow for that fact to be taken into account. So that would lead to an order not drafting, but something like, if you go with disapplication as part of declaratory relief, disapplication pending or until amended, so that one doesn't have, as it were, anything which suggests that the relevant paragraph in Schedule 2 is now gone and defunct and has been implicitly repealed.
Well, I know we shouldn't draft a committee, but surely just get the concepts right. The structure will be, one, a declaration that the legislation does not conform to the law.
Yeah.
And is that in a particular clearly defined respect. Two will be I agree there's conceptual difficulties here, but essentially a suspension of the effect of Para 1 until a date. That's all it'll do, isn't it? That's all it'll say.
Well,
So it won't have to be, say, pending anything. It'll just say until a date. And then there'll be a liberty to apply. That'll work, won't it?
Well, yes, and I'm not, as it were, drafting the order. You haven't got a draft.
No, but I'm
conceptually.
Conceptually.
But the only marker I'm putting down is that it has to allow for that way of changing the legislation. It would be legitimate.
All right, I'm sure it does have to allow for that, but it wouldn't go anywhere near that. All the order does is say the current apparent law doesn't reflect the law, to however we suspend.
My lord, yes, it may be helpful before we have a violent agreement about this to have a look at paragraph 100 of the Liberty judgment, in which the form of declaration there was very much in the form that my lord is putting to me.
I only learn from the best.
I was going to say, Sir James, that it may be helpful if we could be given, perhaps over the short adjournment, a copy of the declaration that was actually granted in the Liberty case.
My lord, I'm sure you can, but I'm pretty sure it followed the form in which you proposed it might. Is that in paragraph 100 on page 505? My lord, so the real question then that remains is timing and the stages that have to be completed from where we are now, in effect. There are they can be broken down into 4 stages. Assuming that we get to a final draft and work is still ongoing in relation to as it were, an internal government final draft of the regulations and possibly any accompanying guidance. But as soon as that is done, stage 1 would be to get that to the Office of Parliamentary Counsel. That could be done within a matter of days of that process being finalised. The Office of Parliamentary Counsel, you won't be surprised to hear, are a pretty busy organisation. And the turnaround, even on an urgent basis, that could be expected within that office realistically is something like at least a couple of weeks. And there would then need to be some time built in for reaction to any suggestions or alterations that OPC produced to the draft. So if we're taking the timetable forward from today, we're probably talking about a period to complete that process sensibly that takes you up to roughly the end of October. The second stage is then that there is and has to be consultation with the ICO, the Information Commissioner, under section 1822 of the DPA. It is plainly better and more sensible if that consultation occurs when a stage of relative finality has been reached within government and with OPC, but assume for the sake of argument that starts the beginning of November. There does need then to be a proper bit of time built in for the Information Commissioner to consider that, and for us again to react to any thoughts or information.
It could be done now, couldn't it? It could be done as soon as there's a draft available. It's not ideal if you were doing everything in a very leisurely step-by-step process, but there's an important degree of urgency here.
And well, there is an important degree of urgency.
And I don't see any reason, in principle, why you shouldn't be, possibly even, from a much earlier stage than now, but certainly from now, where it's clear from what you've said that the draft is in a near final form to go to the Office of Parliamentary Counsel, to say to the ICO, this is what we're intending to send to the Office of Parliamentary Counsel. Obviously, there may be some further changes as a result of that, but what are your views so far?
Well, we certainly could do that. I don't for a moment seek to say we couldn't do that. The only question is whether that's a sensible and efficient way of doing it in circumstances where the OPC genuinely and often does come back with useful and helpful suggestions, not merely of form but of substance. And so, of course, the process can be started. Of course, there's a degree of overlap and parallel. I mean, my lord, perhaps if I give you the stages, we can work out that there are some of them which could happen.
Yes,
in parallel,
by all means. So that was the second stage, consultation.
But that's the
with
second
ICO.
stage, both consultation and reaction.
Yeah.
And we built in a period of, say, 3 weeks on that. 2 weeks for them to think about it, a week for everyone to react. But of course, there are elements of that that can be brought back and that could go in parallel. But that's the second stage in any event. And of course, at the end of that, then, any alteration from a previous position that's been submitted to ministers would then have to be probably resubmitted to ministers before it formally started going into the parliamentary process. The third stage is therefore the beginning of the parliamentary process, and that is the involvement of the Joint Committee on Statutory Instruments. Their scrutiny is integral to the proper passage of, and the efficient and effective and timious passage of affirmative resolution procedure regulations through Parliament, and a core part of that process is pre-scrutiny. In other words, regulations, once they're pretty much in the form that they get to at the end of stages 1 and 2, go for pre-scrutiny to the JCSI, and they themselves are busy people, and they themselves are much less easily suborned into parallel process than much less in the gift of the government as to how long they take. But they are, for understandable reasons, again, busy people, and there's a limit to how much one can truncate that timetable, particularly given that a part of it may fall within recess, which is 9 to 15 November. And again, one would the estimate of that process, even with some urgency, is between 2 and 3 weeks for pre-laying and pre-laying scrutiny. And as I say, that is a super important part of the process because that seeks to ensure the smooth passage when they are formally laid. But again, if there's a period of 2 or 3 weeks for that, that eats into the timetable. There are then the formal processes of Parliament that have to be gone through, with again more limited ability in government to ensure a timetable that can be truncated in a particular way. But just to outline the stages of that process, the JCSI again will look at matters even if they've had pre-scrutiny, and although hopefully that can be much shortened if the effective pre-scrutiny process has happened, so there is a degree of overlap between their formal consideration, but they always look when the thing has formally been laid, and they always reconsider. So there'll need to be some time factored in for that, a week, a couple of weeks, whatever it may be. Slots have to be found. Again, everyone appreciates the urgency of this because of the backdrop of a declaration of the kind that you're considering and a finding of incompatibility. Usually it would be 6 to 8 weeks for affirmative resolution procedure to go through. It very much depends.
When you say to go through, I mean, the affirmative resolution procedure, forgive my ignorance, we're talking about both houses, aren't we?
We're talking about both houses.
And in both cases, there is a debate.
There is.
I don't know whether there are conventions as to how long the debate, time allowed for debate would be, but can you help us on that?
I don't know how long are allowed, but you've got to find a slot, and you've got to
No,
find
well,
a
I
slot
understand that, but
within-
I'm just... when you say 6 to 8 weeks, once you've got a slot, that slot, even if it's a whole day, is a whole day, and that's it. And at the end of the day, there will be a decision.
This isn't a 6 to 8 week debating period, no.
No, I
This
understand.
is-
Well, that's really the point I'm making. It's really simply about finding a slot, and when you, of let us say a day, and if you find 6 to 8 weeks, if you're talking about 6 to 8 weeks, you're effectively simply saying it may take 6 to 8 weeks to find a slot because there's they're, as it were, pre-booked.
You are. I think it also builds in that JCSI section. So you've got to do the JCSI formal review and clearance of the thing as laid, and then you've got to find a slot.
But let's just think about this. If Parliament reopens, the recess ends on the 15th of November, I can't remember when it rises for Christmas, but effectively we have got a period of a month plus, in which, if we were to accept the respondents and the ICO's submission, we would have, you would have to find a time for the Commons, a time for the Lords to debate appropriately, with the JCSI having reached it first. That doesn't sound unrealistic. It may be difficult. It's always difficult to find parliamentary time, but the consequences are important and it'll have to be found. Or if it isn't, you have to put up with the consequences.
Or you might have to exercise a liberty clause.
Well,
Yes.
well, you might do. That's part of the reason for going through the timetable. I mean, having gone through the timetable, there's a degree of flexibility I entirely accept in relation to consultation with the ICO and whether that can be progressed, however unideal that might be, given the urgency. There's a pretty much set period for pre-legislative scrutiny by JCSI, and if you don't do that, you run the risk that it becomes less efficient rather than more, and we very much hope that if that is done properly, the time needed for them formally to consider it afterwards would shrink. But you're still, even on that timetable, getting up to a period of beginning mid-December, taking into account the recess, before you are laying, effectively.
Yes, but you could find the slot beforehand. You don't have to wait till the JCSI have looked at it and then you often find a slot by which time there may only be 3 weeks left and it's full of urgent pre-Christmas business. You start now. Parliamentary managers.
My lord, I don't know, I'm not sure. I'm not sure one can assume that parliamentary managers could be sent off on the hypothesis that it will all reach those stages. I mean, they may be able to do that. I know not, but it's not so simple to find parliamentary slots for debates of this kind.
Sorry to interrupt you, but initially, at least, in the submissions we've had so far, in writing, the suggestion was being made that the instrument would be laid before Parliament by the end of January. And that if I think in the reply submissions it was suggested that if everything had to be gone through, then we should really be thinking of about the end of April.
My lord, I'm back from there, if I may say so.
So you,
I'm back from that timetable.
that's helpful.
That's what I've been trying to do. I've been
That's
trying to explore
Sorry,
whether
we've started asking questions too soon.
No, that's very helpful to know.
And I've been probing, you will understand,
Yeah,
to try
I
and see
understand.
which bits
Where
can be
were you
truncated,
going to
which
end
bits
up,
can
Sir
be-
James, before we ask you
I'm
any
going
more
to end up
questions?
with laying earliest beginning mid-December.
Well, I've just been looking at Erskine May, which very helpfully is online now, as you know. And it does tell us what the procedures are for affirmative resolutions.
I'm
I
rather
haven't
hoping
read
that was in the
detail.
French statement as well.
But most of these affirmative resolution motions are dealt with in the Delegated Legislation Committee. This is what I've got in front of me. And those instruments that are debated in the Chamber are subject to the provisions of a standing order which limits debate to 1.5 hours. That's what it says. That's what it tells me. But I don't know whether I've got the right paragraph.
And I've no idea what the parliamentary timetable looks like, how easy or difficult it would be to get there. What I'm trying to get to is a realistic and sensible period, which is driven by the urgency, which everyone understands, but doesn't, as it were, end up with what would be thoroughly undesirable, however much one might have liberty to apply built in, which is the hiatus. And I fully appreciate that the court was originally looking at end of April from us. That's not where I am now.
So where you are now is laying beginning mid-December. Have you altered your position on whether the time should be defined by terms of laying or of end result?
My lord, we have. I'm not going to die in a ditch to say laying. That wasn't,
Right.
of course.
Okay. So laying.
So it's a disapplication from this date, which is what creates the risk of hiatus.
Yeah.
Which is why I want a realistic timetable, even with something built in that says
Right.
unexpected things happen. And if that's so, the position I'm now at is mid-December for laying, beginning mid-December for laying. Then, of course, there is Christmas, and of course there is some degree of urgency. But if you went for a period of, say, 6 weeks from the laying, that would take one to probably end of January.
So your position really is that a reasonable time, given the urgency, would be January 31st.
That's my position, and I would very much like, with that, recognising that there's a degree of overlapping, there's a degree of uncertainty, there's a degree of managing parliamentary timetable over which we have limited control. For those reasons, I would still like in the liberty to apply provision, but that we respectfully
Well,
submit
that's
as realistic.
Mr. Jaffe is allowing you that, but obviously the longer we gave you the first time, the stronger the mood music would be about our reluctance to accede to an application.
My lord, yes. I've faced strong mood music before in this context.
And I do recall that in the Liberty context, I think it was done on the very last day of the 6-month period. At least the legal framework was in place.
What you didn't see was how fast the swan's legs were moving.
No, I can well appreciate that, but I'm simply making the point
yes.
that it's just human nature.
It does
isn't
take
That
time.
Having a date does tend to focus everyone's minds.
And I'm not disagreeing with that.
Yeah.
And I entirely accept that. The only question is, do you set it realistically? And the factors in favour of setting it slightly longer, it's only another month between the parties.
Right, the
that we're now
dispute has now become end of December or end of January.
It has, and I do respectfully submit, with the liberty to apply, I do respectfully submit that that's not an unreasonable, as it were, a slight extension on the timetable, which everyone otherwise now accepts as realistic, and would be sensible.
Can I ask one question about this? I think I know the answer, but that takes into account, does it, the stage identified in paragraph 24 of Mr. Prince's first witness statement, that is to say, what happens after the motion's been passed in Parliament?
My Lord, I think it does, realistically, because I think there's enough flex in there to do that. It may be
I mean, it could take effect immediately. That could be the provision in the
yes.
SI. That
I mean, it may be worth adding on 7 days to do it, because
Yeah.
obviously it would be undesirable, not asking for the whole 21, but it would be undesirable for the thing not to be promulgated with a bit of fanfare and a bit of explanation so that everyone could understand before it came into force. So we're talking about the period between the making and the bringing into force. And I would respectfully submit that although the usual position is 21 days, particularly for negative resolution procedure, it tends to be slightly shorter, as I understand it, for affirmative resolution procedure regulations. But I do submit that some process for that would be sensible and appropriate. So whether that takes one to the first week of February or not is a matter for you. I mean, we obviously can't do this so stacked up that it becomes, because there are elements of overlap, that it becomes so prescriptive. But my submission would be either end of January if you're feeling really horrid, or first, second week of February if you're not. That's ultimately the realistic choice that I present to the court. Bearing in mind the advantages of that last point, and of the need for everyone to understand that it to be a period of promulgation.
Do you have at your fingertips when Parliament sits again in January?
I don't, but someone might be able to tell me almost immediately on that.
It doesn't come back very quickly, any more than courts do.
It doesn't. It tends to rather replicate the court's, but
4th of January.
4th of January?
4th of January.
Oh, well.
House
Earlier than us.
Earlier than us. Right. Well, that looks as if it did. Thank you very much indeed, Sir James. Any? Sir Jaffe, anything you want to say?
I've taken instructions and we don't object to the 1st of January. Which saves me from a long discussion about how long it takes to put something in front of the Joint Committee on Statutory Instruments and how long it takes for pre-legislative scrutiny.
So, that really leaves only the issue about stroke. If we are ourselves, don't have to go with your agreement. But yeah. And on that, anything more you want to say?
No, not really. It continues to be the appellant view. There's just no evidence before the court that would justify anything other than an ordinary, immediate declaration in respect of conduct by the private sector. And it would have been perfectly possible for the respondents, if they wished to adduce evidence of actual or even potential problems that the private sector would have if there were immediate disapplication, and none has been adduced. Indeed, the opposite has been said. It's that my learned friends have said that it would be extremely unlikely for the private sector, in their view, to be able to use the immigration exemption at all at the moment. Now, whether that's right or not, I don't know. But nonetheless, their position is that there is, in fact, unlikely to be any problem. And so the ordinary order can be made rather than an exceptional one, in our submission.
Thank you very much. We will take a short time to decide where we go from here.
All right. Just to remind you all, the live streaming is still running because they may adjourn for a moment.
As soon as you get that. Yeah. Okay.
Council, are we ready?
But,
They'll be here in a minute, I'm sure.
it was snarky, not very accurate. to have contributed to the unity of the Union. We all kind of angsty down there about looking at absolutely pear-shaped. Back in your box, though. Completely booted out. There's some new solicitor general, which would be very nice. Really under no circumstances. That'd be a sensible and cool idea. Not least because the advice he's giving you is obviously right. The polls are taking a right old draft of their court. They're going to say EU law is supreme after all. I thought that was the kind of constitution. I thought that was the basic tenet. We thought our problems.
They're taking some of the missing competence points.
Is that what they're doing? It sounds a bit more fundamental than that. It sounds like they're taking section 2 of the 1972 Act is all rubbish.
Fundamentally consistent with the Polish constitution.
I can't believe they were allowed to. Anyone would have thought they were allowed to sign up on that. So they created their own.
They've created some new body, in effect, which shapes stuff that people can agree with.
As a Supreme Court.
They're just packing the court.
Yeah.
That doesn't happen in the United Kingdom.
Should be done subtly. It's good.
Very extended period of time.
I bumped into Brenda the other day. She gave me one of those looks. I said, what? What are you doing? Me? It's the court. That's my hand, nothing I can do about it.
To be fair, your submissions haven't changed.
No, absolutely good.
The reception.
It's just the reception they receive.
Yeah.
There's a lot more. You're putting it very fairly, Sir James. It goes a bit further than that.
That was the enjoyable bit. The CLC records were about the only institution James got was Phil saying, well, I mean, you said this. Doesn't go further.
We had it in X on the passport. Right, crikey, here we go. And at the point where Kate was standing up, Phil said something about the Ulla point, Ulla title. So I said, well, I'm not sure that submission's even open to you. Keep going. You realise it's all
decided to close your bank account pursuant to our contractual terms and conditions. You say, why have you just closed my bank account? We can't close it. Well, we don't have to. See you next week.
Yes. Court rise.
Thank you. We're grateful for the very cogent and succinct submissions that we've heard. We do not propose formally to make an order today, but we have decided what our decision will be, and it is right that you should know now so that plans can be made on that basis. So the decision, the order when we make it, will be for a declaration in accordance with our earlier judgment, but that will be suspended to the 31st of January 2022 without any distinction between public authorities and private persons. There will be a liberty to apply, but the court is likely to take a great deal of persuasion that there should be any further extension of the suspension. We will circulate to Council a draft judgment giving our reasons as soon as possible, and the actual formal order of the court will be made at that stage rather than now, and consequential matters obviously will be dealt with at that stage in the usual way following the circulation of the draft judgment. It would, in the particular circumstances of this case, be helpful to have a draft order from the parties now rather than waiting until they receive, because you know what the judgment is going to say. So if you could do that as soon as possible, preferably agreed, if not agreed, rival versions with short reasons on any points of difference, and that, as I say, should include consequential matters. The request to have the form of order made in the Liberty case still stands. It needn't be done over the short adjournment, though it might just as well be. Thank you again.
Court rise.